Hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
I'm going to fix my chair. There we go. Sorry about that, folks. Good morning and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Peter Sachs. To my left is Justice Andrew D'Angelo. We are your panel for the 3 cases that we will be hearing today. I know most of you have been here before, but briefly to go over the rules, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read everything, so you should get right to your arguments. With that said, we call the first case, Commonwealth versus William R. Wheeler, docket number 24P549. Mr. DiMaria, when you're ready.
May it please the court, good morning, Your Honors.
Morning.
Were there is an equal chance that either of 2 individuals could have been the driver, the prosecution cannot meet its burden of proof, and Mr. Wheeler's motion for required findings should have been granted. This case is very telling. The court granted a Creighton motion. Despite this, the prosecutor never asked for an in-court identification, and the lady who—
2 people that there's an equal chance for driving were the defendant and his woman companion. I don't know if they were married or not. But
his ex-wife, yes, Your Honor.
ex-wife? Okay.
Yes,
so the victim says that when she was driving down the street, the person coming the other way, well, the car coming the other way was driven by a man.
Your Honor, it seems as though from her description of the crash that it happened very, very quickly.
But she said it was a man, didn't she?
She did, Your Honor, and I'm questioning that identification.
Well, she didn't say who it was. She never said who it was, in the sense of that's him sitting right there at the defense table. But she did say it was a man, so how is there an equal chance that it was a woman?
Your Honor, no one probed her angle of view or what type of observation she made, and so I would submit that without seeing the wife, without comparing the 2, we just cannot know. But again, I think the bigger point is the prosecution could have simply said, was it this man sitting right there? And they never did that. So I would submit that there's no direct evidence, and the trial judge really seemed to find it problematic that no in-court identification was made. And
the question of operation, though, I'm not sure that issue, I know you're challenging sufficiency of 3 different elements, but on operation, I'm not clear that was preserved.
My understanding, Your Honor, is that for a motion for required finding, you don't explicitly need to preserve it. Even if you don't make a motion, the court still reviews to see.
Well, there's a difference, though, right? Are we looking at prejudicial error, or are we looking at substantial risk of a miscarriage of justice? Because I'm not clear that operation was preserved.
Even if you look at it as substantial risk, I think the outcome would be the same. No in-court identification was made. There was no—
Doesn't she refer to him on the stand as Wheeler at one point?
She does, Your Honor, but only after defense counsel on cross-examination begins using the name Wheeler. She never uses that name on—
That's evidence. She used the word Wheeler. That's evidence. We're looking at this in the light most favorable to the Commonwealth.
She doesn't know who Wheeler is, though. She never used the name on direct, and I would say it's very different on cross-examination when defense counsel kept referring to Mr. Wheeler. Defense counsel never said, Mr. Wheeler standing right next to me. He just kept using the name Wheeler, and she surmised, perhaps.
You know, our cases with Creighton and its progeny in some sense, disfavor in-court identifications because of how prejudicial they are. If identification is not an issue in the case, meaning that defense doesn't raise the issue of identification, can't the jurors in this case assume that the person sitting at the table of the defense is the actual defendant who was arrested and charged?
I suppose they could, Your Honor, but in this case, the identification absolutely was challenged.
Well, the challenge was whether he was the actual driver, whether it was him or his, at that point, his wife was the driver of the car. Not that the person sitting at the table has been misidentified. Don't you see that as a distinction?
I do, Your Honor. I still think the better course is to ask for an in-court identification. And in this case, there's no evidence that Mr. Wheeler had car keys in his possession. The officer never testified the driver's seat was consistent with his height.
Let me ask you about another aspect of operation. Isn't it somewhat uncontested that the defendant drove back to the scene? So isn't that good enough for operation? And
put his car behind the victim's vehicle.
let's concede for a half a second. I'm not saying for purposes of our decision we will, but let's put aside whether it was the wife or the husband who drove initially. When he drives back to the scene, that's it, isn't it?
I thought he testified that he pushed the car back to the scene, Your Honor.
But it's the light most favorable to the Commonwealth.
She testified, the victim, at transcript 55, "I next saw the defendant when he came back to the scene and put his car behind my car."
And at that point, we have a third actor in play. We have Mr. Wheeler's friend, who he rents a room from. Recall, Your Honor, there were 2 defense witnesses on top of Mr. Wheeler, the third one, Austin Campbell. And so because she says the man, it could be Mr. Campbell who came and drove.
No, she testifies that she saw the defendant get back into his car, drive it back to the accident scene, attempt to line up his tire marks behind her car, which was still sitting in the front lawn of the house.
That is correct, Your Honor, but again, she
That
didn't.
wasn't Campbell, that was your guy.
We don't know who it was, Your Honor, because there was no in-court identification. And the judge really seemed to struggle with that. The judge was very surprised that there was no in-court identification.
So when the officer approaches, he speaks to the victim in the other car, he approaches your client who was, quote, standing by his vehicle that was involved in the crash, transcript 63 and 66. The officers then ask, is the male that was near the car in the courtroom today? And he identifies your client. He identified him and said he was the only party standing next to his vehicle at the scene. Again, the lens we're looking through, light most favorable.
Okay, Your Honor, I would still disagree, and in most cases, it seems as though the defendant is in the car in these types of cases. Even if the court were to find that Mr. Wheeler was the operator, I would submit that there is insufficient evidence of negligent driving and impairment. I'll address...
Crossing the center lane and crashing into the other vehicle isn't evidence of impairment or negligent operation?
Your Honor, the exact quote from the transcript, the complainant was asked, did you cross over?
Not the complainant, counsel. The police are the complainants.
Okay, so Ms. Malik, I apologize, Your Honor. She was asked, did you cross over? Were there lines in the road? That's a terrible question. It's a compound question. She replies, yes. You could read that to say, yes, she crossed over, and there were straight lines in the road. Then she then says, and he crossed it coming into my lane. So you basically, she contradicts herself, it seems. At first she says, yes, when asked, did you cross over? Now, I would submit there's no evidence of weather conditions. There's no evidence of speeding, swerving, fishtailing. In most negligent driving cases, there's a lot more. There's direct evidence. In Charland,
Is a car accident negligent operation?
Not every car accident, Your Honor. You need something more than just...
Is crossing over the center line and crashing into another car a negligent operation? That's a hypothetical.
It could be, it also could not be. If the road was icy, if his view was obstructed.
Let's assume perfect weather conditions and someone crosses over the center line and hits another car and then tells the police officer he had 3 drinks. Is that negligent operation? Because that's what happened here.
It could be a mechanical issue with the car, Your Honor. It could be swerving to avoid a pothole, even if you have perfect weather conditions. And I think my big problem with this case is the prosecution could have elicited testimony about all these things. What's the weather? What are the road conditions like?
I think we can always look at a case and say we could have done a better job as the prosecutor, as the defense attorney, but we have the facts that we have. We have a car that is alleged to have crossed a center line, crashed into another vehicle. The operator admits to, well, your client admits to the police officer that he had 2, possibly 3 Angry Orchards. He was driving back home. The car is registered to him. It's owned by him. He drives the car back to the scene. He's next to the car and the only one next to the car when the police arrive. Tell me what case that you have that is similar to that fact pattern where we have reversed the conviction on sufficiency.
I do not have one, Your Honor, but in my brief, I cite multiple cases: driving the wrong way through a rotary, speeding in a residential area at night, starting and stopping repeatedly, swerving all over the road, fishtailing, and so on. So if the court compares my case to those cases, I'd say mine is far, far less. And again, Your Honor, and I realize we look at it in the light most favorable to the Commonwealth. When asked, did you cross over, Ms. Malika responded yes, before later saying, and he crossed into my lane. So the first part, yes, implies she crossed over. But also, Your Honor, she doesn't really testify about what happened. She says, and I quote, "She was going up the street and the car was coming down the street. I'm driving, and next thing I know, I get hit by a car." That's a very, very vague. I realize the prosecution could have done better, but that's a very, very vague description to find and convict someone of negligent driving. In terms of...
Did your client admit at booking that he was driving?
He did, Your Honor.
What do we do with that?
I would submit that there is nothing to corroborate his confession, or his admission, I should say, that he was driving. In one case...
Isn't this a jury question? The jury decided, when was he lying? Was he lying at booking? Was he lying at the scene? It seems to me they decided he was driving.
Your Honor, in the one case, its name escapes me, I apologize. The Supreme Judicial Court found that even though the wife's cigarettes were on the passenger seat, I believe that's Leonard, that was not enough to corroborate the confession. In the other case, Mullen, the car was...
Isn't there plenty of corroboration that the other driver said she sees Wheeler get out of the driver's side, she sees the wife's get out of the passenger side, she calls the driver he, and then she testifies he drove back to the scene. I just pointed out 5 potential corroborations. The case law on Lennon and its progeny is there just needs to be a little bit, ever so much, to corroborate a, quote, confession or admission. Those 5 things I just stated, doesn't that corroborate it?
I would say no, Your Honor. The cigarettes weren't corroboration, and Mullen, the fact the car was owned by the gentleman, was not corroboration. I think the lack of an identification really hurts the Commonwealth, combined with the fact we don't know if the wife had her hair up, if she had a hat on, or so on and so forth. We don't know what kind of view she had. I don't believe she testified at all about the passenger next to Mr. Wheeler. And again, Your Honor, I don't think this court should really tolerate the lack of an in-court identification. It seems as though the prosecutor just forgot to ask, and we shouldn't have to infer and surmise when he could have point blank said...
Did the wife ever tell the police at the scene that she was driving?
She testified that she did. The Officer Wanot, said that she did not. So I realize we look at that in the light most favorable to the Commonwealth, and according to the officer, she did not. And I would submit, lastly, I realize I don't have much time, that there was insufficient evidence of impairment. And my issue in this case is twofold. Number one, Mr. Wheeler said he had 2 or 3 drinks 7 or 8 hours before, but the officer prejudged him. He testified that he had his mind, and the quote, Your Honor, was mind made up before administering the field sobriety test. In some cases, you could see someone and absolutely say, wow, they're completely smashed, they're drunk, I know it when I see it. In Sutter, for example, the defendant was passed out in his car, beer bottles inside, outside, and so on. In this case, all we have is a moderate odor, glassy, bloodshot eyes, and slurred speech.
And the car accident.
A car accident in and of itself is not dispositive, Your Honor, but you are right, we do have.
Totality of the evidence.
There are so many cases, though, where you have a car crash and the person's not intoxicated.
And an admission to 3 drinks.
7 or 8 hours.
You have to look at all of it.
You do, Your Honor, but that was hours before. And I will say as well, going back to the negligent driving, the prosecutor could have asked Mr. Wheeler when he testified, or his ex-wife when she testified, about the weather, the road conditions, the manner of operation. None of that was done. And if the court sees the booking video, I had not included it because the officer...
You have it.
Oh, you have it? Oh, wonderful. Oh, the Commonwealth must have put it in, but he's not slurring his speech. He's not stumbling or anything, which kind of calls into question the officer's testimony. I just think if the court compares the facts of this case with all the cases cited in my brief, this case will just show that there was insufficient evidence to convict Mr. Wheeler.
So this accident occurred in August, right? So we wouldn't be talking about snow and road conditions. My memory is the accident was in the summer.
It was, Your Honor, but there could be blinding sunlight, there could be rain, there could be a pothole on the road, there could be any number of things.
All right, unless the panel has any other questions, and I don't see any, we will hear from the Commonwealth.
Thank you.
Thank you. Ms. Simonian?
Good morning, Your Honors. May it please the Court. Elizabeth Simonian for the Commonwealth. Today, the Commonwealth respectfully requests that this Court affirm the judgments of conviction for the charges of operating under the influence of liquor and negligent operation.
So why not just have her identify him in the courtroom?
I would agree that it was most likely better practice to have the other driver identify the defendant in court as the man who operated that vehicle today. I would also agree with Your Honor D'Angelo, as he was speaking to my brother, that at times that in-court identification can also be prejudicial. But that it may have been better to just ask her, is that the man who operated? But that is not fatal to the Commonwealth's case here, because the Commonwealth produced ample circumstantial evidence to show that the defendant was the sole operator of that vehicle that day. We have the defendant's 2 admissions to driving, 1 at the scene, 1 at booking.
Do you think it's preserved, the question of operation sufficiency?
It's not very clear in the transcripts. I believe at some point I would have to look back at the transcript.
If he moves to a required finding, does he have to articulate which element?
I don't believe he has to articulate exactly which
Because you
element.
analyzed it under substantial risk, so I was curious about that.
I don't think it was preserved here. Again, it wasn't very clear from the transcript, but yes, that is how I analyzed it. We also have the other...
The result the same under either standard, whether it's prejudicial error or substantial risk?
Whether it may have affected the outcome of the case.
Whether or not there's sufficient evidence of operation?
I am not 100% sure of the answer, but I believe that either way there is sufficient evidence of operation in this case. We have a lot here. Like I said, we have those 2 admissions. We have the other driver's testimony. She testifies to a him driving the car. She observed on the stand, she says, Wheeler exited the driver's side, the wife exited the passenger side. We have Officer Wanat's testimony that he observed Ms. Malejka at the scene, so we know that she was there and he spoke with her. The defendant was the only party standing next to the vehicle. The car was registered to the defendant, and he cooperated with field sobriety tests.
What's your closest case to this fact pattern that found sufficient evidence?
Off the top of my head, I point to a myriad of cases on pages... Give me one moment. I would say that Peterson is quite guiding here. We have, in that case, there was circumstantial evidence sufficient to support operation, where the defendant was the registered owner of the crash car and lived in the neighborhood. Those facts exist here. The defendant appeared intoxicated at the scene. That fact appears here. The defendant confirmed he had been drinking. Also appears here. The defendant agreed to and complied with field sobriety tests. Also here. And there was no evidence tending to indicate that somebody else other than the defendant was operating the vehicle.
Well, but isn't that the question? I think that opposing counsel is really arguing deterioration of the Commonwealth's case once the ex-wife took the stand and said she was driving. So can you speak to that, please?
Sure. I would say that if we are looking at the alternate theories produced by the ex-wife, we wouldn't be taking the evidence in the light most favorable to the Commonwealth. But on that point, if we look to Commonwealth v. Nguyen Huynh, 452 Mass at 485, deterioration only occurs where the Commonwealth's prima facie case has been shown to be incredible or conclusively incorrect. Deterioration does not occur simply because the defendant presented contradictory evidence. That is what we have here.
Did you cite Quinn in your brief?
I did not. We also have Commonwealth v. Vaughn. That is out of this court. There were 2 robberies, and the defendant was convicted of the first. I did not cite to that case in my brief. There was the same person in both robberies and a myriad of coincidences. There was alibi evidence presented there. That is just, and then he was incarcerated at the time of the second robbery. So that fact pattern goes to show an example of where the Commonwealth's evidence was incredible or conclusively incorrect. Because he could not have been that person in both of those robberies. That's not the case here. We just have contradictory evidence presented by the defendant, the ex-wife, and Austin Campbell, who was the roommate. And we must take the evidence in the light most favorable to the Commonwealth, which would prove the element of operation here.
Counsel, can I go back to the identification for a second?
Sure.
I quickly just reviewed Creighton. Perhaps the prosecutor didn't have the witness identify the defendant because there was no prior out-of-court identification. And the case law says he then can't do it during the trial. So when that situation arises, like in this case it seems to have done, how does the Commonwealth prove identification?
I would say that they prove identification through exactly the evidence that they produced here, and it's that other driver may not have identified the defendant in court as the person who drove that vehicle, but we do have the officer's in-court identification as the man that he arrested that day. And if you look to all of the facts prior to the defendant's arrest, there is a chain of events where it's clear the defendant never left the scene or was out of eyesight from anyone. The victim was...
So I want to play that out a little bit.
Sure.
Perhaps for future cases. So I'm going to call her the victim because she was the victim of the negligent operation. So the victim can't identify the defendant in court, but she can say, I got hit, I followed the man who was driving to the scene, the police show up, and they can then say, we arrested that guy, and from that, they can then, the jury or the fact finder can infer that those 2 people are the same.
I would say yes. The jury can make the reasonable inferences from the evidence. That is what they did here. I mean, yes, she may not have identified the defendant in court as that person, but she said a wheeler hit her. A he and a him was driving the vehicle.
Well, using the name of the defendant, unless she learned the name of the defendant at the time of the accident/OUI, that's even more prejudicial than saying that's the guy right there. I mean, she must have learned that from an outside source, which probably, if somebody objected, would have been sustained. She can't testify to the name unless she learned it from the defendant himself. So I'm trying to figure out where is the prejudicial line here. If the court is saying that's the guy right there who hit me, assuming there's no prior out-of-court identification, which in this case maybe there wasn't, where do we draw the line regarding prejudice? That's when I'm a little bit struggling on this case, because we usually do have that's the guy.
Yes.
Either because there's a prior out-of-court identification or defense doesn't object or something like that. But in this case, there is no in-court ID, maybe for a good reason. So it seems inferential, but it's a little bit of a
It may be hard to draw the line of prejudice in this case on that one fact. I would argue that it might be a little harder if we didn't have all that evidence. But we do. We have, when we draw all the evidence in the light most favorable to the Commonwealth, we see that there is that evidence. Yes, there was no in-court identification. I understand that piece. If we didn't have all of the other evidence, maybe it would be more prejudicial to the defendant, but that's not the case here.
Did the court provide, and I can look, but did the court provide any type of final jury instruction regarding identification?
Yes, if you look to transcript pages 90 through 91, this is where the court made the determination that she was going to allow the evidence here, although there was no in-court identification made by the other driver. She said, let's see. She said, "You may find that the defendant was the operator of the motor vehicle, even if no witnesses saw him driving the motor vehicle, if there's enough circumstantial evidence to prove to you, beyond a reasonable doubt, that the motor vehicle was operated and that the defendant and nobody else was the operator." Okay. So she took that issue under consideration, and she decided that there was sufficient circumstantial evidence here. Moving on to the impairment evidence, I would also say that that is certainly sufficient. What the Commonwealth produced here was certainly sufficient to find that element as well. We have the car crash. We have the 2 admissions that the defendant was drinking. In fact, although my brother says he admitted to drinking 7 to 8 hours before, if you look to the booking video, specifically at 19 minutes through 19:30, he states that he drank a 3rd cider right before he left Southwick. So those are 3 drinks right there, and we can tell that at least one of those was drank right before he left the location he departed from.
But on the field sobriety test, he does tell the officer that he has arthritis in the knee, and that could go to at least one of the problems that he had completing them, right?
I understand, but also what undercuts that argument is that, yes, the defendant said that for the 9-step walk and turn, but then you look at the one-legged stand test, and the officer gives him the opportunity to stand on whatever leg he chooses. And although he just complained of his arthritic leg acting up, which was his left leg, he chooses to stand on that left leg for the one-legged stand test. So I would argue that subtle fact right there undercuts the defendant's argument on that point.
Do you agree with Brother Counsel that a car accident in and of itself is insufficient for negligent operation?
A car accident, and there can be accidents. There's single car accidents, there's love taps that happen. This is not that case. There was the cross over the line. When there's a cross over the line, it appears there's negligence somewhere, but it wasn't just
But could you answer the question, please? Do you agree that there can be a car accident without negligence?
I agree.
Okay.
I would agree.
Thank you.
You're welcome. But here, it's a high-impact car crash that pushes the other driver's vehicle onto the front lawn of somebody's residence. There's visible damage to both vehicles. The officer says that the other driver's vehicle had significant damage to it. There's the impairment evidence, the failed sobriety tests, and then again, the admissions to drinking. So I would say that that evidence also supports the negligence requirement. But the statute here for negligence only requires proof that the defendant's conduct might have endangered safety of the public, not that it in fact did. Here it did endanger Ms. Malechka's life through that car accident. We have case support.
But that doesn't go to whether it was negligent, does it?
Well,
Negligent conduct, and it has to endanger, and that might have endangered the lives or safety of the public. So those are 2 separate things.
I'm sorry,
They're 2 separate elements. The operation has to be negligent, and it has to have at least the potential for endangering the lives or safety of the public.
Correct.
Okay. So the fact that there was that the car was pushed up on the lawn, or generally speaking, the severity of an accident doesn't necessarily prove that it resulted from negligence.
I understand. But here we have that high-impact car crash, plus all the evidence of intoxication. We have, under Commonwealth v. Ross, 92 Mass Ap Court at 380, there's no car accident there. There's erratic driving, plus intoxication, plus a residential neighborhood, and the element of negligence was satisfied. Here we have a car accident. I would say that our case is stronger. So here, if there are no further questions, again, the Commonwealth respectfully requests that this court affirm the judgments of conviction in the Chicopee District Court complaint. Thank you.
Thank you. The case is under advisement. Excellent arguments on both sides. I wanted to note, Ms. Simone, it appears that at the time you filed your brief, you had not yet been admitted to the bar, and I assume you are now, so welcome to the bar, and I hope you'll come back to the appeals court.
Thank you.
Thank you. The case is under advisement. Our next case is Commonwealth versus Christopher Eaton, docket number 24P779. As counsel approaches, I just want to remind you that this case is partially impounded, so please do not use any names of any victims or relatives. Thank you. Good morning, Mr. Gleason.
Good morning, Your Honor. Morning, Your Honors. Scott Gleason on behalf of Mr. Christopher Eaton. Two fundamental issues I'd like to talk about today. Number one is the admission of the other act evidence, and two issues were raised by the judge at the trial court during the motion session. One was the nature of the relationship of the parties, and number two was state of mind. There was a third issue that was raised by counsel. I'd like to address each of them individually.
Can I start at the back up a step and ask whether these objections that you're advancing here are preserved? In particular, the motions in limine were both directed at out-of-state other acts, prior bad acts conduct. And so there was a ruling on those, which arguably preserves your objections to the out-of-state conduct, but you've given us a list of 7 different items of bad act evidence, and 4 of them are in Massachusetts. So I'm not seeing how the objection to those is preserved.
All right, and Judge, I do understand the point, but if my memory serves me correctly, 2 of them came out inadvertently during the course of the testimony, or...
But there was no objection at the time either.
I understand. I'm primarily going to focus, for purposes of my discussion today, in particular on the spooning in Connecticut. I'm going to particularly focus on that particular item. And I do say that with regards to those 2, my argument doesn't change. Number one, with regards to the relationship of the individuals, this is a 4.5-year relationship involving certainly a middle-aged man with a very young lady, girl, and the fact of the matter is she was referring to him as daddy. They were living together for the majority of that time period. They moved back and forth from one state to another. They were engaged in visits with their respective families on a regular basis, coming from Connecticut to Massachusetts. They actually had evidence in the case where, according to the alleged victim and the mother, the victim and the mother, there was Cocoa Beach going...
Counsel, but I guess when you're using, and sometimes it's a litany, the relationship of the parties that the case law talks about, I don't think the courts mean the relationship like this is a father-child relationship.
Agreed.
I think it's, does it go beyond that? In this case, it's more than father-daughter, it's father sleeping with daughter, or at least getting into the bed with daughter. That's the relationship of the parties that I think the case law talks about. So why is that a problem in this case? That's what it was showing.
Well, in terms of that specific objection, that specific issue of sleeping in the bed, the fondling and the touching and the like are another matter. The sleeping in the bed is not something that is necessarily, because apparently, according to the mother, it was something that was done. They had one bedroom in Connecticut, and the 3 of them would share that one bedroom, and it was separated by a bureau in the mirror. Now, having said that, my focus is because having done, unfortunately, many of these trials, they're extraordinarily difficult cases to do. And in particular, when there's a gap of years. So I think that the justices have to be very cautious with regards to what they allow in to make it even more prejudicial, because the very fact of the matter that a 30-plus-year-old is with an 8-year-old engaging in sexual relations in and of itself creates profound possibility of prejudice. Certainly all of that attempts to get
But that's
verified.
not unfair prejudice. What we're concerned about with admission of evidence is unfair prejudice, and evidence of the charged conduct isn't unfair.
Of charged conduct, did you say?
Charged conduct.
Yeah, oh, absolutely. Well, that's certainly not fair. That's all.
Okay? So the question is whether the bad acts evidence is more prejudicial than probative.
Right, and that is
Unfair,
getting back
and I
to...
should say unfairly prejudicial.
All right, and that's why I'm talking
So
about...
what was unfair about the evidence of the spooning? Wouldn't it have looked odd and perhaps unbelievable to the jury if the conduct of the defendant had occurred all in Massachusetts but somehow stopped whenever the parties went to Connecticut?
Well, that is
Doesn't the jury need a complete picture to know that, yes, the victim is telling a coherent story here, or at least to allow the Commonwealth to present her full story so the jury can evaluate it?
And I don't disagree with that. And as a matter of fact, that's a very interesting point, and it was raised by very competent counsel. But the fact of the matter is this, is that it's not just that they moved to Connecticut or, for example, moved to California. They were coming back on weekends on almost, as I read the testimony, almost on a regular weekly basis. They were coming back, visiting with both families. Now, in an abundance of caution, my view is first, the judge had to deal with the nature of the relationship, which I believe there was voluminous there, and I would suggest the evidence speaks to that. It didn't need any further evidence of any kind, number one. Number two, the state of mind.
You say that no additional evidence was necessary. Aren't there a number of cases, the Oberle case, the Coppney case, the Mass Guide to Evidence, that say that whether prior bad act evidence is necessary to the case is not a prerequisite for its admissibility. The question is whether it's more unfairly prejudicial than it is probative.
Right, and exactly.
Because the Commonwealth can try to prove its case as strongly as it wants to.
Yeah, that's correct. And they had all the evidence in the world in Massachusetts with 9 indictments.
But wouldn't it look strange if, the time sequence here is a little bit unclear about when exactly some of these Massachusetts acts occurred. So isn't the Commonwealth allowed to kind of fill in the Connecticut part, at least with evidence of the Connecticut part, so the jury can consider that the victim testifies that this was going on in Connecticut at the same time?
Well, what's presumed, and if I may just address it, is that when they're having the meeting prior to trial, the issue becomes, if the defense files a motion, I want those kept out, then, well, counsel, first of all, it's spooning in Connecticut, a 30-year-old with an 8-year-old, and the fact is that's horrifying, and the judge said it's highly prejudicial. He admitted it's highly prejudicial on page 24, I believe, during the discussion. And it's very simple. Okay, counsel, you're right. It is highly prejudicial. But if you bring it up that there's this issue that counsel raised during the course of that meeting that, oh, by the way, I don't want anybody to think that there wasn't anything going on in Connecticut. Well, the fact of the matter is that's the easiest balloon in the world to shoot down, because of the fact of the matter is they're coming back on a regular basis, and there's a cautionary instruction. Counsel, fine. You want all that kept out?
I'm not understanding your argument about the easiest balloon to shoot down. The jury, whether anyone explicitly raises it in testimony or argument or not, could find it odd that if the victim had testified that a number of incidents occurred in Massachusetts, but when they were at home in Connecticut during that period, nothing ever happened.
Well, that's my point. Cautionary...
So, why can't the Commonwealth, in its case, fill in the evidence that things were happening in Connecticut so that the jury won't be wondering about it.
Okay,
What's unfairly prejudicial about that?
Because what I'm suggesting is in the discussion, when the issue is being raised by the defense attorney, okay, listen, we'll keep it out. But if you raise the issue that, well, wait a minute, there's this problem, how come nothing happened in Connecticut? Now you just made it relevant and it all comes in. A cautionary instruction in order, because the first issue that has to...
So are you saying that the judge should have ruled, I'm not going to allow in any evidence about other acts in Connecticut unless defense counsel somehow raises the fact that, well, you don't see anything happening in Connecticut, do you? And that should cause you to... Is that what you're suggesting? Just so we understand your argument.
Yes, because if in fact...
Okay.
If in fact...
So the Commonwealth is not allowed to head off speculation by the jury that might happen whether defense counsel raises it or not?
Well, Judge, the issue, the problem... First of all, I agree with your point.
Could you answer that question?
I agree with you.
Is the Commonwealth allowed to eliminate the possibility, the likelihood that the jury is going to speculate about an apparent hole in the victim's story by filling in the evidence?
But my point is that there is no hole if they're testifying on a regular basis, that they're returning to Massachusetts.
The chronology is not that clear. We don't have an exact alleged date for any of these acts.
And isn't the defense at trial, notwithstanding what state we're in, that the victim's story just made no sense?
No, in addition to that, I didn't say it made no sense. What I am also saying...
Sense, transcript 6, page 80, defied common sense.
Okay, Judge, if I may, getting to the issue of Connecticut, 104B also requires a review of, contrary to what I read in the transcript from the trial judge, that there has to be some reliability. In this case, there was an investigator from Connecticut involved, and with regards to, doesn't it strike the court in terms of why was no charge brought for spooning in Connecticut by the state of Connecticut? And in terms of reliability, there is, because the fact of the matter is, not that it's the, but in terms of reliability, what evidence is there other than Connecticut heard all of this and investigators involved and elected not to prosecute? That is extraordinary. And there is only one inference that can be drawn. They had issues with the credibility of it. There was something going on there. So with an abundance of caution, when someone is facing these horrific charges and having a very difficult time putting together any kind of a defense to where was I 10 years ago, how the heck do I know where I was 10 years ago? And oh, by the way, as to worrying about speculation, what the jury might be thinking, it's very simple to handle it. It's, okay, counsel, okay, you got a good point here, but you raise the issue of Connecticut. You raise it like, well, how come nothing happened in Connecticut? You just made it all relevant. It all comes in. Now, if I may proceed to the second piece of it, which I also think is extraordinarily important. This is an amendment after trial. Now, an amendment after trial...
What would you...
It's not after trial. It's at the close of the Commonwealth's evidence.
Yes, Your Honor. Thank you.
And what would you have done differently had the time frame been amended earlier, or you were on notice earlier?
Okay. And if, first of all, the very fact that is the point. One of the things the judge was asking questions of, and I'm going to answer directly your question, but if I may come from a little different angle.
Well, because the question is this amendment as to form, and was there prejudice? So I want to understand what you would have done differently.
Okay. Because I would have asked the question, how come, if we knew it, how come it hasn't been investigated? How come how come police didn't go if they knew 4 years earlier when these complaints were coming about? They thought it was April, and how incredible in terms of trial preparation and investigation of a case is it that no one asked the mother when it was that this Cocoa Beach event took place?
Couldn't those arguments have been made, and weren't many of them made to the jury anyway, and assisted by the judge's instruction about you're not to speculate about whether their additional investigation of Coco Key in May and June would have turned up anything else? You need to take the evidence as it is.
He did, I thought he did make that instruction. Now, but having said that, Judge.
So the question is,
I'm sorry.
didn't the defendant make the argument that you're talking about now? How would he have been able to make it any more strongly if the amendment to the indictments had occurred earlier?
Well, that's a terrific response, and true.
What do you mean it's a terrific response? How was the defendant prejudiced?
The defendant is prejudiced because what should have happened in this case and didn't happen is the first thing that the trial judge should have done is said, well, counsel, you just found out about this. It happened on a Thursday, the 21st, I believe, or 21st of September, 2023. First witness, 9 a.m. in the morning.
I don't see where you're going with this.
Well,
How was the defendant prejudiced?
I'm going to answer. I'm answering it.
Okay, well, you're taking a long time to get there.
My apology. I'll go as rapidly as I can. The question was asked on Thursday morning at 9 o'clock. How come the discussion never happened till Monday morning at 9 o'clock? And oh, by the way, in that interim period of time, if it's exculpatory evidence, which it would be, if in fact it was investigated that May and June and the latter part of April, which already appears to be in the evidence, but May and June were investigated. Oh, by the way, there was no evidence in Cocoa Beach. There were Cocoa Keys of them having been there in those months also. And the fact of the matter is, because now what the defense is doing, to answer the question, is they're stabbing. Well, we don't know. Well, we don't know. Do you agree that when you have these cases, sometimes you only have one or two pieces to hang on to? One of them is, I wasn't at Cocoa Keys with her. And oh, by the way,
your time has expired, and I don't know that you've answered Justice Sachs' question. So if you could get to that, and then I'll see if the panel has any other questions.
if that there would have been the opportunity to do an investigation and uncover exculpatory evidence that May and June, they weren't there either. That not only is the child wrong, the mother's wrong, it's inaccurate, it's unsupported by the evidence, and that is fact, not something about a story that comes years later.
Hold on a moment. Let me see if the panel has no other questions, so we will have to take the rest on your brief. Thank you very much. Attorney Jansen, if you need additional time that we gave Mr. Gleason, I will gladly give that to you. It was, I believe, a little under 2 minutes. When you're ready.
Good morning. May it please the court. Catherine Jansen on behalf of the Commonwealth. Commonwealth respectfully requests that the court affirm the defendant's convictions. I'll start first with the prior or other bad act evidence. I think the judge was well within his discretion to admit this other act evidence. I would first start, I think only the Connecticut evidence is preserved, not the other act evidence that occurred in Salisbury. And I would just note that 2 of the other act evidence raised by my brother in his brief were not, in fact, other act evidence. One of them, referenced in the prosecutor's opening statement, was anticipated testimony regarding charged conduct, and another claimed bad other act evidence was part and parcel of a discrete charged conduct.
Opposing counsel in the brief mentions that, and I'm not sure, and this is where the question is going, he was surprised they hadn't been informed about some of the prior conduct. I want to make it clear. The Connecticut ones, which are preserved because of the motion to eliminate, were any of those not disclosed to defense counsel prior to the testimony?
Based on my reading of the record and my understanding of the case, I believe those were all disclosed. I believe that comment was maybe made in response to the earlier Salisbury acts when the victim was very young. And so I think those were based on my reading of the transcript and speaking with the trial prosecutor, which is obviously not part of the record, I'm not sure those were totally anticipated, but in any event, they did play into the defendant's defense that the victim's allegations were incredible, especially given the fact that the victim testified the mother knew about those 2, and yet she did not testify about those. And in any event, the Connecticut evidence, I think as Justice Sachs pointed out, this occurred, because this is a child sexual assault case, these occurred in diverse dates, and the timeline is a little unclear, but based on the indictments and the timing of them, and when this occurred, when they were living in Connecticut and going back to Salisbury, some of these acts were occurring in Connecticut at the same time the acts were charged conduct was occurring in Massachusetts, and it would be inexplicable that this has occurred only in Massachusetts when they're visiting family, opposed to.
When we talk about the nature of the relationship, and I know Justice D'Angelo asked opposing counsel about this, is it your argument that really what you were trying to get to here is that he was grooming her?
Absolutely, that this became a sexual relationship in some way and that he was grooming her. It's not just a father-daughter, parent-child relationship, and the jury's entitled to hear that. And the fact that this was ongoing in both states was important for the jury to hear.
And then as to the amount of evidence that came in under this theory, can you contrast this with Dwyer?
Absolutely. I think Dwyer is on completely different footing. In that case, there were 7 prior bad acts that all predated the charged incidents compared to 2 charged incidents. There were, of the 65 transcript pages, only 15 went to the charged conduct, while 21 went to the prior bad acts. The cross-examination of the defendant was essentially solely focused on discrediting the prior bad act evidence, and the Commonwealth used that prior bad act evidence in their closing. Opposed to here, there were, I believe, initially 9 charges of bad act evidence, opposed to the Connecticut was really more generalized, not detailed testimony, I would suggest. And even with those 2 other Salisbury incidents, if they were to be viewed as prior bad acts, they still didn't outweigh what the charged conduct was. The cross-examination was primarily focused on the victim's lack of precision and memory and that her lack of credibility, and the Commonwealth did not mention the prior bad acts in their closing to bolster their case. So I would suggest this is in no way a situation where it overwhelmed the case.
And it was the judge that directed out 1 ag rape and 1 assault with intent to rape. It wasn't a not guilty after.
The judge directed out, and the Commonwealth conceded, I believe, one of the counts, count 8, I believe, and the judge directed out count 2.
Can I ask a question about the amendment of the indictments?
Yes.
How would a hypothetical acquittal on the original charges of the 2 charges that were allowed to be amended, which alleged assaults in April, how would an acquittal on that bar prosecution on the amended charges which alleged the same conduct in April, May, or June?
That's an interesting question, Your Honor, that I have not thought about, to be fully frank.
Because that's required to make the amendment one of form rather than substance.
Correct, because the time and date is not an essential element of the crime, so what at trial was alleged in terms of the conduct and the essential elements was already proven in terms of just matching the indictment. I'm not totally sure how to answer that question. I hadn't thought about that.
So if the charges had not been amended and what went to the jury was these 2 allegations in April and the jury acquitted, then could the Commonwealth indict and try to prove conduct in May or June? Would that be barred by double jeopardy?
Again, I'm not entirely sure the answer to that question. I mean, based on just on the fly trying to do a double jeopardy analysis, possibly. I'm not entirely sure, and I don't want to give the court, an off-the-cuff answer about that.
If you discover anything after argument,
I will be sure to send the court a 16L letter on that issue.
Sticking on the same topic, and I think this is where counsel was going at the end of his presentation. In this case, there was evidence, not necessarily through the defense, but that the police had gone to Cocoa Key to try to look up the hotel reservations, et cetera, and they didn't find anything.
Correct.
A good part of the defense rests on that, or at least could, to say, look, this trip never even occurred. Now at the end of the trial, all of a sudden, the Commonwealth switches from April to June, and there's no evidence at that point of, well, maybe they did go in June or maybe they didn't go in June. Why isn't that prejudicial?
I would suggest not prejudicial, as Judge Lang had noted, because the cross-examination of the police officer who looked for the records concentrated on one weekend in April, and the entire month of April was charged prior to the amendment. And so I think Judge Lang's reasoning is correct in that you could have said, it's clear the police only looked at this one weekend, so it doesn't necessarily matter that they didn't look at all these other weekends per se.
But I'm focusing on, if you're defending somebody accused of a sexual assault in June, that takes place at Cocoa Key, the questioning would be, did you go to Cocoa Key and look and see if they had been there in June? Yes, we did. And no, they weren't there. You argue to the jury, they weren't even there in June.
And I think
So now they're deprived of that defense because they were only focusing on April.
I don't think they're totally deprived of that defense because of the fact of the nature in which they were cross-examining, because I understand your point that now we're defending in June, but you're also defending a sexual assault that occurred in April, and the fact that the police didn't do a full investigation, but looking at every weekend in April that they could have, and they were able to make that argument.
That's a Bowdoin defense. This is different than a Bowdoin defense. This is a specific, and this is an alibi in a sense. It's the reverse alibi. Victim says, we were here on June 30th, or the mother says, we were here on June 30th. That's when the assault occurs. Defense presents evidence to say, we weren't even at Cocoa Key in June.
I think that the judge's instructions in this case help ameliorate some of the prejudice that you're talking about, because he said you're specifically, to not speculate, you heard that the victim's mother testified that this trip could have occurred in May or June, and that there were no records found, and you were not to speculate whether records existed or not, and so you were able...
I think that made it worse.
Well,
Why doesn't that make it worse?
I'm reading T transcript 5, page 61. The judge tells the jury, you must accept that no corroborative records have been presented as to Cocoa Keys in May and June, and therefore, for purposes of determining whether the Commonwealth has met its burden of proof beyond a reasonable doubt, they do not exist. So the judge is telling the jury there are no records of the defendant being at Cocoa Key in May or June. Isn't that, and I suppose I should have put this question to Mr. Gleason, doesn't that essentially give the defendant everything he could have gotten if he had known before trial and sent an investigator to Cocoa Key?
Yes, I think so, and I think you articulated it better than I was
That's
answering.
the best it's going to get.
I agree, and I think I could have articulated that better to Justice D'Angelo. And so I think at the end of the day, there is no prejudice in this case. And in fact, there are many cases, I would cite to Jones, I believe, which is cited in my brief, where there's no error in amending an indictment to conform to evidence after closing arguments when the defendant's not prejudiced. And here, this happened before closing arguments, so the defendant was even able to, with that jury instruction, make that argument in his closing, and he did.
Can I ask you, in the assembly, it says that the defendant filed a motion for a bill of particulars in April of 2021. There's no subsequent action on that motion. Do you know if a bill of particulars was filed and answered in this case?
Off the top of my head, I don't know the answer to that. I did not see that in the assembly, but I'd be happy to look into that for the court.
I don't see it on the docket. If one had been filed, would that have been docketed?
I believe it would have been. That's the practice. If there are any further questions, I'm happy to answer them. Otherwise, I'm happy to rest on my brief.
I don't see any other additional questions. We will take the matter under advisement. Always a difficult case. Counsel, you both did an excellent job. Thank you both. Our last case this morning is AMP Electrical, Inc. versus WM SCHULTZ Construction, Inc. and another, docket number 24P941. And as counsel approaches, I understand the appellees will be sharing their time equally. Is that correct?
Yes, Your Honor.
Thank you very much. When you're ready, counsel.
Thank you, Your Honor. May it please the court, my name is Bart Heemskirk, and I represent the appellant AMP Electrical, Inc., an electrical subcontractor electrical contractor in West Springfield, Massachusetts. The question asked that I hope it will be answered consistent with the statute is, under the public bidding law, can an electrical filed subcontractor be required under any circumstances to do in excess of $80,000 worth of excavation and concrete fabrication? I think the starting point for me is the law with respect to what is the role of the general contractor. Under the statute in public construction, the general contractor under Section 44E of Chapter 149 is responsible for all the work shown in the specifications in the drawings. And that's reflected in Article 1 of the general contract in this case.
Can I ask you something that's perhaps more specific, because I think I'm just confused, and I'm hoping you can help me. The addendum here, numbers 2 and 3, seem to require your client to perform excavation, backfill work, electrical duct bank work, which is what I believe your client is now saying is outside the scope of work. So what do we do about the two addenda that seem to say that was your client's responsibility?
The two problems with those addenda are, first, they are not specifications for the excavation work.
So what are they then?
Well, one is a note that is an incorrect question to an answer, which makes no reference to any specifications. And one is a drawing that is a drawing. Okay? So that's one. And two, even if they were specifications, they are not contained in the electrician's specifications.
So are they not part
under
of
the
the
statute.
contract? Are they superfluous? What are they?
They're part of the general contract, and which goes to my first point, is they are work of the general contractor, because they are not specified as part of the electrician's work.
The form for the sub-bid on which your client submitted its bid, which is at Record Appendix, starting at page 341, on page 344, Article 5, basis of bid, number 5.2. This sub-bid includes addenda numbered 1, 2, and 3.
Yes.
So why isn't that sufficient to put the bidder, sub-bidder, your client on notice that what's set forth in addenda 1 and 2, particularly the drawing that was attached to 2, is your client's responsibility?
Because two reasons. One is it's not electrical work, but secondly, just because we say any sub-trade is bound by the addenda, they're only bound by addenda for their sub-trade if there are specifications, specifications for their sub-trade in the addenda. In other words, I could put in...
Specifications can't be incorporated by reference?
They can be. They just weren't here.
Why doesn't this do that?
Okay. Well, the first addenda, are we just talking about the one with the drawing?
Let's just talk about the second one right now, the drawing.
Yeah. So addenda 3 says, addenda 3, which was submitted 3 days before the bid filing deadline, says we've amended drawing 401, I believe. And drawing 401 had suddenly on it a drawing of the subject excavation and the concrete fabrication work. So first of all, the statute says that the trade is bound by specifications and drawings if necessary. You need a specification, first of all. So this is just a drawing. It's not a spec.
It's not just a drawing 401, it's drawing E401.
Yeah.
What does the E stand for?
The E is used on the plan to mean electrical.
Okay, so when your client looks at addendum 3 that says here are some changes in the project manual and here are some revised drawing sheets, I mean, I can see that there are a dozen of them listed there.
Yes.
And it would be pretty daunting to go over all of them, but if I were an electrical contractor, I would go down and say, okay, which ones of these begin with E?
And he did.
E101, E201, E301, E401, E801, E802, E803. I would look at those and make sure, because those are about electric work. I would look at those. Why can't we hold your client to that?
He did look at those, and there's two points to the answer. The first point is, again, the general contractor owns all the specs and all the drawings, whether they say E, B, C, or D, unless they show work that is work of a specific subtrade.
Just asking about terminology, is electrical work a subtrade?
It is. It's one of the subtrades listed in 144F.
Then what is a trade, if electrical is a subtrade?
Oh, well, it's only a subtrade by virtue of the fact that it's a subcontractor. A trade becomes a subtrade when he becomes a filed subbidder under 144F.
Where do we find that principle set forth? Because there are no definitions for purposes of 44F that define trade or subtrade that I could find?
I think they're just listed in there as trades and
Well,
subtrades.
there are references to trades, and there are also references to subtrades. So how do we know what's what?
I think they're one and the same. I think a trade becomes a subtrade when it's a subcontractor to a general contract.
Well, that's kind of curious that the legislature would use two different terms in the same statute to mean the same thing.
Yeah. But I'd like
Is there
to
any
answer the second part of your question before I...
Is there any case that tells us that, or any regulations or opinions
I think
of
maybe
the...
every case and every statute I've ever read just assumes that to be true. And it's never occurred to me that it's a material issue. In any event, and then so now all the plans, unless they describe work of my particular trade, our plans are owned by the general. Now, when I, the subcontractor, in this case the electrician, look at E401, I'm looking at it in preparing my bid, whether it's in an addenda or in the original plans or the specs, when I'm the electrical filed sub-bidder and I'm preparing my bid, I look at all the plans and all the specs and I look for electrical work. And that's all the statute tells me to bid, the electrical work. It doesn't mean I bid excavation and concrete fabrication, even if that's posted on a drawing with an E on it, or a drawing that shows other electrical work.
Well, the subcontractor, the electrical, who's an expert in the field, has no obligation whatsoever to, if there's confusion about what that means, to go and say, wait, is this my work or is this the general contractor? I mean, Justice Sachs pointed out things that to a layperson who has no electrical background, I look at it and say, that looks to me to be like electrical work. So why is that not an obligation of the electrician to say, I'm confused, is this my work or is this somebody else's, before you make a bid?
Because there's no confusion in the electrician's mind. By the way, when he made the bid, it was 3 days after they put that drawing on the plan.
I understand that, but he accepted it, so.
But an electrician knows what is the standard in the statute is customary work of the particular trade. The electrician knows that excavation is not customary work of the trade.
What in the record do we have that shows that anyone else in the field would have known that this was not covered?
Well, we have the engineers who wrote the spec, and they said, when AMP did object, what do you mean we're electricians, we don't do excavation, and we don't do...
Yeah, I know that's what they said.
Yeah, right.
You said customary in the field.
And they filed an affidavit on the summary judgment record to that effect.
But you said customary in the field.
That's...
What in the record is there that this was not customary in the record, that this was electrical work?
Because when AMP raised its objection, the tie and bond engineer who wrote the spec said, well, they could just sub it out, which is also in violation of the public bidding statute. So the town, the engineers are the awarding authority. And they didn't make a determination of rationality because they admitted in a letter that, just sub it out then, which Schultz's brief admits that we couldn't just sub it out. So the town never made the determination of what if the engineer for the town never made the determination as to whether or not this excavation was customary part of electrician's work. The only thing in the record is AMP's affidavit that it is not at all, and the town's own engineers in the documents filed by the general contractor have them saying, well, they should have just subbed it out then, which is wrong under the statute.
What case is there that says what you're telling us?
That's the problem. There are so few cases, and the SJC about 20 years ago, I think, said that this statute is a skeleton, and now 20 years later, it still is. But what I've So we're left with the Attorney General's bid protest department opinions, which are recorded in the social law library, one of which I handed up in the motion session. And that gets into the whole thing about how you can't sub and how the town has a duty to rationally determine, their interpretation of the statute is the town's duty to make a determination as to what is customary for a particular trade has to be rationally based. That's an Attorney General standard, the rationally based, and that's in the record. And that's what we lawyers rely on more than anything. We don't rely on a lot of cases because we don't have them. And so as far as rationally based, the town, according to their own engineers who write the specs, didn't make any rational decision at all. They said you should have subbed it out. And I think that's the end of the case for whether or not excavation work of this magnitude, more than just incidental filling a hole with sand or something, of this magnitude, I think that's the end of the case on this record.
I have a factual question for you. Could you tell us what part of the Plan E401 designates the work that's disputed here? I'm looking at the sheet. It's page 368 of the record.
It's a picture of, do you have an appendix site
I'm
for me?
looking at the sheet. Is it the
368.
diagram that's labeled concrete encased duct bank that's called out in some kind
Yes.
of cloud outline?
Yes, that's it.
And what about the items 4 and 6 that are similarly called out in the notes below that?
Yes.
Are those?
Yeah, because there were probably more than one of them.
Well, if you're looking at it, then
I'm
maybe-
not.
Okay. Maybe I'll ask the SCHULTZ the same question, but as far as you know, it's the 3 items that are called out in the kind of cloud-shaped outline on E401.
Yes.
Okay, so then my other question is a legal question. What language in 44F says that subbidders are entitled to rely on doing only the work listed in the specifications for the division corresponding to their trade or subtrade and needn't read any other documents?
Such specification shall have a separate section for each of the following classes of work, and an estimate of the awarding authority such class will exceed $25,000. Then it lists all the trades, so everyone from electricians to plumbers and so forth, they have their own section. And that's one of our arguments here is those drawings didn't put them into the specification section for electricians. Each separate section of the specifications prescribed or provided for this paragraph shall state the time limit for filing subbids. I'm trying to find.
Shall specify by number each sheet of plans showing work to be done by the subcontractor under such section.
Yes.
And was E401 specified in the bid, the sub-bid?
It was, but the aspects you're showing are not electrical works. They're not customary work performed by.
Okay, so this is my question. Where does 44F say that even if work is shown on a drawing or a plan for a particular trade or subtrade, identified as being a plan for that trade or subtrade, the bidder doesn't have to do it?
It says, my eyes aren't going right through it, but it says somewhere in the statute, each subtrade shall bid all of the work for that subtrade.
And does it prohibit anyone from bidding work that doesn't clearly fall within some other subtrade? I mean, that's somewhere on the border, like excavating and filling? Do you agree that if the contractor has to run a conduit between 2 buildings that are 10 feet apart, and the conduit has to be buried 6 inches deep, the contractor, electrical contractor could be expected to dig that trench, put the conduit in
Yeah,
and fill it.
yeah, incidental,
Okay, so
yes.
So not everything.
Right,
but
not
it's
not
pure
everything.
electric work.
And one thing like excavation, this is interesting, to me this is interesting. Excavation is not listed as a subtrade. And that's why you see in this contract, and virtually every subcontract, under the general conditions for the general, are all these vast boilerplate excavation
Counsel, I'd like to
specs.
follow up to Justice Sachs, which I was going to bring up earlier. You mentioned it earlier that minor excavation is the work. And as Justice Sachs just gave you an example, how do we draw the line if you're saying that your client shouldn't draw the line? I mean, I have no idea. People, digging a ditch to me, yeah, that's excavation. But if I hire an electrician and he has to dig a ditch and he's taking on the job, I'm assuming he's going to do that. So again, it's back to what are we supposed to assume your client believes is his part of the work?
Okay, so the three answers, I guess, are these. One, the awarding authority, the engineers, have to make a decision as to what's customary. And in this case, clearly they didn't do that. We know that from the record. Two, if you're going to say something is customary and put the subcontractor on notice, you don't tack it onto a plan 3 days before the bid. You put it into the spec, the Section E spec, and so the electrician can say, hey, wait a second. That's not usual and customary. They don't have to put in Mr. Justice Sachs's example of the short conduit. But for $83,000, I mean, that's the Richardson case where they excused the contractor from a bunch of trenching just because it wasn't usual and customary, and it was an ineptly drawn spec.
I don't see any additional questions, and you have exceeded your time, so I think we're going to have to leave it there and take the rest of your arguments on your brief. Thank you so much.
Thank you, Your Honors.
All right. Mr. McNamara, are you going to proceed first on behalf of Schultz?
I am, Your Honor.
Go right ahead.
Good morning, Your Honors. John McNamara for Appellees W.M. Schultz Construction Company and Endurance Surety Corporation. We ask that this court affirm the judgment of the lower court in favor of Schultz, Endurance, and the city of West Springfield. As Your Honors are aware, this was a publicly bid construction contract under Chapter 149-44A through F, which requires public general bids from a general contractor and statutory filed sub-bids from a bevy of filed subcontractors. Because it is a public bid, the general bid is non-negotiable, as is the scope of the general contractor work. Similarly, the scope of the filed sub-bidders, specifically in this case electrical, the scope is non-negotiable and the price is non-negotiable. All bidders submit their bids directly to the awarding authority, in this case West Springfield. This affirms the equal footing principle that all bidders bid on the same work in the same manner and bear the same risk of rejection. Now, with every construction project, public construction project, questions do come up pre-bid as to the intent, the meaning, and the scope. And because the bidders cannot have separate discussions with the awarding authority or the engineer, there's what's called a request for information, or RFI process. Pre-bid, bidders submit questions to the awarding authority, which the awarding authority, through its engineer, will answer and publish in addenda to the bid documents. And that's exactly what happened here. A prospective electrical sub-bidder submitted a question, and specifically it was question number 15, as to whether certain excavation work was the work of the electrical sub-bidder. In addenda number 2, pre-bid, The city of West Springfield answered that question in the affirmative. That electrical trenching work is part of the electrical filed sub-bid work.
Do you agree that AMP could not have subbed out this work after it was awarded the?
No, absolutely not, Your Honor.
I think they could have.
Every subcontractor, be it a filed sub-bid subcontractor or a non-filed subcontractor, subs out a good amount of work. For example, the mechanical contractor, specifically on this courthouse, would do the HVAC system, but they would have a subcontractor to do the automatic temperature control work beneath them.
Is there anything in 44F or the cases or other, that part of Chapter 149 that tells us that a filed sub-bid that's accepted leaves the subcontractor free to sub out aspects of that sub?
Specifically in 44F, that it's accepted that subcontractors sub certain sub-trades of work. I don't think it's specifically set forth.
Can you point us to any case where that practice has been approved, even implicitly? Any reported case?
Well, 44F also states that if the awarding authority wants to know the identity of particular sub-trades, they can request that the bidder identify that sub-trade on the bid form.
Even on a filed?
Yeah, yes, Your Honor, and that's called a subparagraph E listing.
Where is that in 44F?
That's Chapter 149, 44F, subparagraph E.
And when you're using the word sub, in this context, it's actually a sub-sub.
It's a sub-sub, Your Honor. So, and the awarding authority has the ability to request the identity of the sub-sub if they have an interest. For example, you are building a new elementary school. All of your schools are on one particular automatic temperature control system. The awarding authority would say, we want our new school to also be on that system. You have to list under subparagraph E the identity of that sub performing the work. So we are confident our schools will speak to one another. That is something the awarding authority has the ability to request, but not the requirement to. And they could not require any identification of any sub-subs, and there are teams of sub-subs.
Counsel, regarding the question that a sub can ask the engineer, you said in this case there was one question 15. The addendum was made, according to opposing counsel, 3 days prior to the bid. How does the answer to question 15 get put out to prospective bidders?
In addendum number 2.
Okay.
Which is published to every prospective bidder. And I would also direct the court's attention to addendum number 3, where the electrical plans, specifically E401, pre-bid, were modified to require this work to be performed by the electrical subcontractor. Notably, these are on the E drawings, the electrical drawings. They are not on any other drawing.
Because your time is ticking fast, I have a completely different question to ask you, which is that the town has raised in their brief that you did not appeal the dismissal of the town from the case. You're not making an issue of that on appeal.
Your Honor, yes, to address that head on, SCHULTZ moved for summary judgment.
Right.
And it was a unified summary judgment. The town essentially filed a Me Too brief. We approached this as a unified appeal.
Mm-hmm.
The trial judge below made no independent findings of any issues between the town and SCHULTZ and said our liability and the town's liability was derivative of the first party claim. And I would just like to focus the court on, we've cited this language in our brief from Crocker v. Piedmont Aviation, which is a federal appeals court, DC appeals court, which says, of course, an appellee might respond to this procedural handicap by filing a cross appeal, as Piedmont did, on this round of appeals. But this imposes significant burdens on the appellate court. Cross appeals are required only when the prevailing party below seeks to enlarge the scope of that judgment.
We do cross appeals all the time. That's not new and exciting for us. My question, I guess, is if we were hypothetically to affirm the trial court judge in all respects, you're not raising an issue as to Springfield.
No.
And
Again,
are you seeking fees not pursuant to a statute, but pursuant to the claim that the appeal is frivolous?
Yes, Your Honor.
Okay. Your time has expired. Let me check with the panel.
I just did want to verify that on the drawing E401, is it?
Yeah.
Do you agree that the work at issue is the work that's called out in the cloud-shaped outline?
Yes, it is called out in the cloud-shaped description.
The drawing and the two notes?
And the notes as well. And in the construction industry, specifications are often included on plans, and that's exactly what Ty and Bond did on E401. That's all you need to know how to perform that work.
I see a little triangle and looks like a 3 inside it, next to each of those items. Does that somehow signal that this is a change or an amendment to the
That
prior?
means that's the third revision.
Third revision. And where were the first two?
On the prior bid documents. So what this does is pre-bid E401 revises that, and this is the third revision of E401. But the notable fact is that this was done prior to bidding, so all bidders had notice of it. If there are no further questions,
Your time has expired. Thank you very much.
Thank you.
Mr. Petrini?
Thank you, Your Honors. May it please the Court. I'm Christopher Petrini for the Town of West Springfield, the third-party appellee in this case. And as my brother counsel set forth, the town is of the position that the summary judgment decision should be affirmed, that there are really no disputed facts at all, and that has been acknowledged by the appellant. And there are basically 6 main reasons that support the motion for summary judgment decision.
Before you do your list, can I just ask you, opposing counsel mentioned that there's no cases. I know there had been a request for direct appellate review here that was denied. If we were to affirm the trial court judge, is there something here that you think is publication worthy that would be helpful to the bench and bar on these issues?
I really don't, because I think it's all really covered by the filed subbird statute, Chapter 149, Section 44F. In several locations in that statute, the statute does specifically mention that the bid documents include not only the specifications, but they also include the plans, and they also include the addenda. That's actually written 3 or 4 times right into the Chapter 44F, the filed subbid. So in our view, the appellant has taken a very overly restrictive and really non-industry standard view of the specifications here.
Counsel, you just said something that built into what co-counsel said. So you take the position that E401 is basically a specification?
Yes, exactly. And it's within that subset. It's a form of a specification, exactly. And for that reason, basically the plans and specs, actually the electrical specification itself, and this was noted by the trial court, it's at the addendum, page 24, Exhibit 22, Section 16131, specifically notes how certain of the work was to be, some of the trenching work was to be conducted, and the addenda was issued because the excavation part of that work wasn't clear, and there was a question asked by the bidder, and in our view, the addenda basically opened and shut this case. That's how construction work is done. It's been done that way for decades. If parties, both bidders and contractors and public authorities, who I tend to represent in my practice, cannot rely on the addenda process, then the whole process for identifying and segregating and allocating work and bidding will be thrown into a disarray. I really do think there's an important public policy issue here. If you can't rely on addenda, I think it opens up a big can of worms.
So based on what you're saying, I assume, again, joining co-counsel, that the comment made by the engineers that you can just sub it out is entirely appropriate.
Yes, absolutely. It could definitely be subbed out. As my brother counsel stated, that subparagraph E work, there is a requirement if it's so-called subspecialty trade work. But that's a highly specialized type of work here. Excavation is the bread and butter of construction. It happens on a lot of these subcontractors end up doing it themselves.
Can I ask, when you refer to subparagraph E, looking at the statute, is it subparagraph 2E? Because the first subdivision of 44F seems to be a 1.
You just
There's
double check.
1A, and then the next designated subdivision is 2. And then 2 has, in parentheses, and 2 has
Yes.
a number of lettered, okay.
You are
So-
correct, Your Honor. Yes.
All right, so then does that correspond to, I'm looking now at the subbid filed by AMP at, the relevant page seems to be Record Appendix 345. There's a paragraph 5.7. It says, it gives a space to list the names of all persons, firms, corporations furnishing to the undersigned subbidder labor, materials for, et cetera, work shall be listed below.
Yes.
Is that where the paragraph E information would go if AMP wanted to sub out this
Yes.
work?
Exactly, and they chose not to, and so but it's the public authority and the engineer just assumed that they were going to be doing the excavation work themselves, and in fact, that is routinely done. And it is important to note that in several other locations, AMP specifically acknowledged that their bid acknowledged that they had received and interpreted and accounted for the addenda. And the fact that it was 3 days before, that was actually for E401. That doesn't matter because, as Your Honor, Justice D'Angelo pointed out, they bid on it anyway. And actually, addenda 2 was not that it's a big deal, but that came out about 10 days before. And then there was one 3 days before. But either way, everyone was given notice and the contractor did bid on it. And similarly, the subbid itself and the subcontract itself, again, and these are all statutory subcontracts, they specifically note that the addenda is included within the contract documents, within the specifications. So, Your Honor, in this case, I've been practicing for 35 years, and I usually don't request that fees be considered at this level. It's something I haven't done before. But here, where it's just so black letter law here that this addenda in question is part of the contract, that asks Your Honors to respectfully consider awarding appellate attorney's fees and costs on the issue of our procedural issue vis-a-vis my brother counsel. We're just going to rest on the briefs on that. You don't even have to reach that if you simply affirm the Superior Court. So if there are no further questions, I'll conclude my argument.
Just check. I don't see any. Thank you, everyone. This case is now under advisement. This will also conclude this morning's sitting of the Appeals Court. I would like to thank our staff, including our court officers, law clerks, and our wonderful timekeeper. We are now in recess. Safe travels back to Western Mass.